International University College of Turin. So I now hand the floor over to Mr. Papastergiou.
Ευχαριστώ πολύ.
Thank you very much. I will speak in Greek. I represent an association which is quite old, involved in issues of human rights. Actually, we were established back in 1935, and we have been closed down twice by dictatorships in Greece. And I'm a member of the administration of the Athens bar. However, my topic is to be expanded from the viewpoint of a lawyer who quite frequently works in criminal cases. The importance of interpreting in criminal cases is self-evident because in Greece and in many other European countries, obviously, the parties of a trial are foreigners, people that do not understand Greek at all, and Greek is the official language of the procedure, and they have a different mother tongue. And of course, the main person in criminal procedures is the person accused, of course. Interpreting is very important for witnesses as well. And even more so, well, we have to say that, in my view, interpreting is important because of the variety of those held in Greek prisons are foreigners. According to the figures of the Ministry of Justice, in a population of 10,000 people in prison in Greece, and 60% of them are foreigners. This overrepresentation might indicate a bias of the judiciary against foreigners. And it could be interpreted in more general terms, the fact that many people that are not Greek citizens, they come from third countries, do not have some basics. For example, their staying in Greece is not legal. And this means that they can be detained more easily. The overrepresentation of foreigners in jails has to do with the fact that these people in criminal procedures cannot address the judges in their own language, and this has to do with the assessment of their claims, and it frequently has to do with the quality of interpretation. In criminal procedures, interpreting plays a role in a series of stages of the procedure. First, we have the pre-interrogation by the police, which is the first stage carried out by the police. Then we have interrogation, then by a judge, the interrogating judge, and the main stage of the procedures, which is the criminal trial. The need for interpretation has to do with the knowledge of facts. For example, they have to know what they are accused of. They should have a proper contact with their lawyer, the advocate, and recording of what they have to say is also important. So they say something in their defense, and this has to be explained properly to the judge. Let me take all these three stages one by one. First, police pre-interrogation. Let's suppose that a 19-year-old young person, an asylum seeker who doesn't know the Greek language, is apprehended by the Greek police close to Athens with a small quantity of drugs. What happens with this person? This young person, is to be led to a police station. Now let's suppose that this person comes from a country, an Asian country, let's say. How is it possible for police officers to question him, to press charges, and how can he explain his claims in front of the police? I think that there are great problems at this stage in our system. Anyway, police pre-interrogation has many problems because it is a stage of the procedure where we see many abuses of the rights of the defendant. And this goes for Greek citizens as well, who undergo this procedure, but especially for people who do not know the Greek language. This police pre-interrogation quite frequently leads to inadequate or even non-existent interpretation. Quite frequently, police officers cannot find somebody to adequately interpret and explain the charges, so they are going to recruit people that know languages that are somehow a little bit understood by the person apprehended. So some people say that they speak Urdu, this is their native language, and police people say, the police officers, okay, this person speaks Farsi, you understand Farsi somehow, and you have to explain the charges in this language. So indeed, and this is a problem that comes up later, there is no corpus of interpreters used by the Greek police on a stable basis to cover these needs, the pre-interrogation needs. Now let's go to interrogation. One might think that in front of the judiciary things become a little bit better. I have to say that indeed things are a little bit better, but there are many omissions, and this has to do with the regional prosecutors' offices. In Athens, the prosecutor's office does have a registry or a corpus of interpreters, and still we don't know if we have enough safeguards, but for regional prosecutors' offices, things are much worse. For example, in the same example, this 19-year-old boy could be apprehended at Grevena or Lamia, which are cities in the Greek region. The problems are going to be great. And in one of my cases at the regional prosecutor's office, I'm not going to name which, the prosecutor's office said that the Google Translate was used to explain the charges. And of course we have the signature of the prosecutor under this. It's quite impressive. I have seen this, and I'm sure, and I'm afraid that this happens in many other cases. Now, hearing date, trial, the main trial. Indeed, there is a register of interpreters at the prosecutor's office of Athens, and there is a provision in our criminal code according to which there is this table, the names of the interpreters, which defines that there is a ministerial decision to be issued. This happened in 2016 with the qualifications of the interpreters. I don't know whether you offer services at the Court of First Instance in Athens or at the prosecutor's office. I was trying to find this ministerial decision, and I found out that probably there is no such decision. There is nothing, no regulation providing the qualifications of the people to be used as interpreters in this very important procedure. On the contrary, there is a ministerial decision for interpreters for the asylum agency. No microphone is used. No microphone is used. Microphone, please. Microphone. Anyway, I have seen no ministerial decision. I searched yesterday. No, it's just a circular letter. It is a circular letter. Okay, the circular letter is another type of a source, a legal law. I didn't know that there is a circular letter, but I have to stress that there is no ministerial decision, and the code asks for a ministerial decision, not a circular. So indeed, we see this from experience. So my experience and the experience of people who work in this type of cases, criminal cases, indicates that indeed court interpreters just know how to speak the language somehow, but there is no certification whatsoever of their interpreting capabilities in a specific way, and they have never been evaluated, and there is no evaluation procedure. Now, the outcome and the results we see in procedures indicate that interpretation is obviously problematic. And I have to say that there are other procedures where this problem is really dramatic. In the Greek justice system, we have the so-called in flagrante, when you are caught red-handed. Anyway, this moves at the border of our constitutional law. So in this case, when somebody is caught in flagrante red-handed, these people are mostly foreigners, because this is the type of crimes: small quantities of drugs, having a gun. We have many foreign people involved in this type of crimes for social reasons. So indeed, some interpreters are called on their mobile phones. We have people that move from one court room to another because they work simultaneously in a court case, and they have to stop to go to see what happens with this other procedure in flagrante. So I think that there are consequences. Some other problems, this lack of accreditation. The interpreters are paid at a very low rate indeed, just to interpret between the person accused and the judge. But previously there should be communication with the lawyer, and they do this on a volunteer basis. There is no additional fee to have enough time to prepare and have communication between the lawyer and the accused person, which is very important to be prepared for the case. Yet another issue: translation of the file, the case file. After 2014, there is this legal obligation, and we do have it in our criminal code, that the important documents of the file have to be translated, and there is also an emblematic, an iconic decision of the court of second instance in Attica, in the Siemens case, because a very important document has not been translated in all languages of everybody involved. But there are deviations from these principles, because we have some case law. There are some court decisions which indicate that if there has been knowledge of the charges at the first stage, we don't have to translate the summoning letter for the second stage. This is a decision by some courts. And then we have some low profile, socially speaking, cases where actually there is never translation of the documents by the public prosecutor's office. Of course, the lawyer can raise the issue and maybe ask for and be successful, but this does not happen always, and some people are judged on the basis of charges they cannot fully understand. So actually, to finish, we would say that the new provisions of 2014, which became part of the Greek criminal procedure code rather, actually this was a transposition of an EU directive about interpreting in the justice system. So indeed we have some terms for qualifications, but as it seems, the ministerial decision has not been issued yet to set the standards, and there is no evaluation process. We cannot say that this interpreter in this language indeed is adequate. On the other hand, we have some poor quality interpreting, and we have to do something about it. And it seems that Greek courts have not decided yet whether all essential documents have to be translated or not. So actually there are many deficits and problems: non-certified knowledge, low quality translation and interpreting in some cases, low rates for interpreters, so there is no incentive for people who really know languages very well. And because of the low rate, needs stay uncovered, the needs for communication with the lawyers. There is lack of interpreters for many languages, especially in regional prosecutors' offices outside Athens, Piraeus and Thessaloniki. But even in these three main offices, there is lack of interpreters in languages that are not that rare. And there are many people accused who did not have the benefit of interpreting in their mother tongue. And I think that we need to be more severe as to the most important documents of the file that really have to be translated to the mother tongue. So I think that we could fully utilize the new legal framework. We could even use the Skype. We could have registered interpreters, accredited interpreters, which is necessary, and they could cover interpretation needs via Skype if necessary for the regional prosecutors' offices. I think that this is a fair change, and of course interpreters have to get a proper remuneration. And because I think that these low rates affect the quality of interpreting in our criminal justice system. Thank you very much.